She accelerated directly at me. I was forced onto the hood of the car, believing I was about to die, and she was laughing at me during this. She stared me in the eye and waved at me before violently jerking the wheel, throwing me off the car.
If any of those people were laughing, but she is adamant she was not laughing. She was not being disrespectful. She really was scared after the exchange of the person in her car with the two victims.
You were operating a dangerous weapon in the form of that car. Does Ms. Ballard want to go forward with the plea? Getting on the record with position 20, it's 25 SC 006282, State versus Ballard. Ms. Ballard is here with Ms. Wood, her lawyer, and Ms. Smith is here for the state. Good morning, Ms. Ballard.
Good morning.
How are you doing?
I'm okay. How are you?
I'm all right. You ready to go forward?
Yes.
Ms. Wood shared with me that you're prepared to enter a plea. There are going to be some conditions to it, but we'll get through all that. So if you are ready, then Ms. Smith is going to put you under oath and then ask you questions about your case and your rights. You need to answer all her questions truthfully. And you need to let me know if at any point you're confused by what we're talking about or things aren't going the way you thought they were going to be going, so we can address that. Will you do that?
Okay.
Okay. Ms. Smith?
Ms. Ballard, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Demoya Ballard.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
22, 11th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Ms. Ballard, do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Can you repeat that for me?
Yes. Do you understand that since this is a non-negotiated plea, that the court can impose any sentence authorized by law, including a sentence higher than what I'm recommending, up to the maximum sentence on each charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on parole or probation, that your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained what the First Offender Act is to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on your first offender probation, that your first offender status could be revoked, you could be adjudicated guilty, and you can be resentenced up to the maximum for the charge in this indictment?
Oh, yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
What was it?
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Oh, yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
You said, do I understand that?
Do you
Oh,
understand that
yes,
these are the
ma'am.
rights you're waiving by entering this guilty plea?
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this plea?
I am.
Ms. Ballard, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 006282, how do you plead to count 1, aggravated assault, and count 2, aggravated assault?
I plead nolo.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Okay. Yes.
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Ballard. Your Honor, if this case were to proceed to trial, the state and the facts would show that on June 8th, 2024, officers of the Atlanta Police Department responded to 543 10th Street Northwest, that's in Atlanta, Georgia, also Fulton County, in response to a fight in progress. When the officers got there, they spoke with the victim, in this case, Mr. Hoffman, who told the officers that him and his fiancee, Taylor Fields, was at that location. I believe it was a Papa John's location to pick up a DoorDash delivery. Once they got there, there was a car that parked behind them that was blocking them from leaving. So they asked the car behind them to move and didn't understand why they were blocking them in. When they asked the driver and the people in the car why they were parked behind them, blocking them, a person in the passenger seat threw out a styrofoam cup toward the couple, Mr. Hoffman and Ms. Fields. At this time, Mr. Hoffman got the attention of a police officer that was in that same parking lot to kind of tell him what had just happened, and to try to avoid any confrontation between him and his car that was parked behind them. While Mr. Hoffman was going to get the officer's attention, Ms. Fields got out of the car to try to get the tag information of the vehicle that was parked behind them. Ms. Fields went around the front of the car. When she went around the front of the car, the driver of the car accelerated, hitting Ms. Fields. After this, the car drove off. Mr. Hoffman tried to stop the car because at this point they hit his fiance. When Mr. Hoffman tried to stop the car, the driver then accelerated again and hit Mr. Hoffman. Mr. Hoffman stayed on the hood around 8 to 10 seconds before he was thrown off. The driver of the car continued down the street and left the scene. At this time, the officers did respond, and EMS also responded to the scene. They both had injuries, but Mr. Hoffman was kind of in a worse shape than Ms. Fields. He had a gash and a laceration in the back of his head where he had to receive staples. Ms. Fields, in this case, she was scuffed up on her ankle and on her arm. However, most of her pain comes from her back and hands, as I've spoken to both of them in this case. At the time, the driver was not apprehended. However, she was through video technology and having her license plate, she was later identified, the defendant in this case, as the driver. Mr. Hoffman, when I spoke with him, he told me that while he was on the hood of the car, the person who was driving waved at him and smiled while he was on that hood before he was being thrown off. However, he did leave his phone on the hood of the car that was never retrieved. At this time, both of the victims in this case, Mr. Hoffman and Ms. Fields, was transported to Grady Hospital where they received treatment for their injuries. A warrant was taken out for the defendant in this case for the facts and circumstances and the two ag assaults we have here. She was later arrested for the charges that we have. And those are the facts and circumstances of the case. Regarding the recommendation from the state, because of the extent of the injuries and also the seriousness of the crime, the state is asking for a 10 serve 5 with the balance probated, and that's for counts 1 and 2 for both of them to be ran concurrent. Regarding the special conditions of probation, we're asking for the defendant to have no contact with the victims. This was a stranger on stranger type of thing. So just in case they run into each other again, for the defendant to stay away from that incident location again, that was like a Papa John's restaurant type of plaza. For the defendant to complete a defensive driving course and to pay restitution regarding the medical expenses. In this case, we're still waiting for those medical records to come back from Grady. However, I do believe that it's a large amount of money that Ms. Ballard may not, it's just a large amount of money. So we'll request a restitution hearing.
Okay.
I did want to share with the court pictures of the injuries from Mr. Hoffman and Ms. Fields. I've told Ms. Wood in this case that I would be showing the pictures during the plea.
Okay.
Is this something that you would like to see on your own, Judge, or would you like me to share my screen on Zoom?
You can share. I mean, this is, if there were a trial, I assume these would be pieces of evidence at trial.
Yes, Judge. 1 second. This is the injuries of Mr. Hoffman. He had to get staples in his head from that fall that he had. These are just other injuries on his arm. I don't know if that's going to load. Oh, here we go. That's on Mr. Hoffman's arm. Regarding Ms. Fields, in this case, I do have a photo of her injuries. I'll share again. Most of the pain for Ms. Fields and her injuries came from back and arms, but this was kind of the scuffing that she had on the bottom of her foot. But those are the pictures of the injuries that I did want to share with the court regarding the incident we have here. The recording of the defendant in this case, accelerating toward Mr. Hoffman was also captured on camera, but it's a bit blurry. I didn't want to show that because I don't know if it would have shown much.
Was it from a surveillance camera at Papa John's, or Mr. Hoffman was filming, or?
It was from across the street, so like a CCTV type of
Got it.
footage.
There was some stationary camera that was just for security reasons recording, and it captured some of what you described.
Yes, Judge.
Okay.
Also, in this case, the state did get a chance to speak with Ms. Fields and Mr. Hoffman. Mr. Hoffman is on the call and would like to make a statement, a victim impact statement to the court. And I'll let him talk about most of how this has impacted him. But from Ms. Fields' side, because she's not on the call, she did tell me that after this, she became homeless. Her and Mr. Hoffman kind of split up, and that was because door dashing was their main source of income. And because they could no longer drive because of the injuries and make money, they could no longer pay for the apartment they were living in. So they kind of had to separate to go to different people's respective homes to have somewhere to stay. Ms. Fields told me that this has impacted her a lot with her relationship, her mental health, her physical health. And she would just like for the defendant in this case to be held accountable. But I'll let Mr. Hoffman also speak to the rest of the statement that he has.
Sure. Good morning, Mr. Hoffman.
Good morning.
I appreciate you joining us, and I'm sorry what you've been through. That was a pretty rough photo to see. I hope it didn't bring back too many bad memories for you of what you lived through. But why don't you share with me your thoughts about this situation, what you think ought to happen, the impact it's had on you. I'm here to listen.
All right, sir. If you don't mind, I've prepared a statement so I can just keep my thoughts in order.
That is okay.
I would just like to speak to the court today, make sure it fully understood the malicious and dangerous intent of the defendant. She did not just act recklessly, she acted with complete disregard for human life. She laughed while the man she was with assaulted my wife by throwing a cup of soda and ice in her face. And moments later, she used her vehicle as a weapon to try to run my wife down. When I attempted to stop her from fleeing and pulled out my phone to photograph the car, she stopped in front of me. But the moment I pulled out my or raised my phone. She accelerated directly at me. I was forced onto the hood of the car, believing I was about to die, and she was laughing at me during this. She stared me in the eye and waved at me before violently jerking the wheel, throwing me off the car. This was not just an accident, it was deliberate, and the impact of that moment has stayed with me every day since. I suffered a severe head injury that required 10 staples, close a head wound the size of a soda can. I now live with a permanent scar, daily headaches, and hair that no longer grows where I was injured, a constant reminder every time I look in the mirror. My left ankle was also seriously injured. I can no longer stand for long periods of time without it giving out, which has permanently affected my ability to work labor-intensive jobs. As was said at the time, me and my wife were living paycheck to paycheck, and because we could no longer work, our lives spiraled into homelessness. Today, I'm sleeping on a floor in the living room, and my wife is sleeping on a friend's couch. I was terrified of even walking through a parking lot. This attack did not just injure us physically, it took away our stability, our independence, and our sense of security. This has changed our lives permanently. Your Honor, I ask you consider not only what happened in that moment, but the lasting damage it continues to cause every day. Thank you for your time.
You're very welcome, Mr. Hoffman. Tell me, are you and Ms. Fields, you've referred to her as your wife several times. I heard Ms. Smith refer to you as being engaged back in June of 24. Are you two still together?
We are. We're just not living in the same place right now because it doesn't make sense.
Sure, but you still are there for each other, just geographically, you can't afford to be in the same place.
That's correct.
Good, I'm glad you're still together. I'm sorry you went through this, and it sounds like it wasn't any easier for Ms. Fields, even though she might not have been injured quite as severely as you. I appreciate you taking the time to be here and to share what happened. It is always helpful to hear from the prosecutor, but it's somewhat necessarily a little sterile because Ms. Smith wasn't there. And so she's reading from reports and relating what she may have heard having met with you. But it's always more helpful for the judge to hear from the people who were involved. So thank you for your time.
Yes, sir.
Ms. Smith-Mann, do you have any criminal history information on Ms. Ballard?
Yes, Your Honor, I do. And I apologize if you hear another court going on. I'm holding two courts at one time.
That's all right.
But I do have some information on Ms. Ballard. There is one prior conviction, not including the one that is before you today. There is one open case out of Cobb County, 6/3/2025 for willful obstruction of law enforcement officers by the use of threats or violence. Nothing further, Your Honor.
What's the conviction that is out there?
It's not, that was one prior cycle.
So there is this Cobb arrest for
Yes, Your Honor.
obstruction, and that case is pending.
That case is pending, and the other case is a case that's before you. So there are two cycles.
Two cycles, okay.
One cycle is before you today.
Thank you.
You're welcome.
Ms. Wood.
Judge, just to let you know about that Cobb case, she had court there yesterday. We're expecting that to be downgraded. So it is still pending currently, but I'm expecting that to be downgraded for her.
So it's felony obstruction as alleged, and you think it will be resolved with misdemeanor obstruction?
From what she was told yesterday, Judge.
Okay.
Your Honor, Ms. Ballard is 22 years old. She was 20 at the time of this incident. She is local to the Atlanta area. She does have an 11th grade education. We are encouraging her. I'm going to ask that it be a special condition of probation for her to complete her GED.
I already added it.
Perfect. She was working at, so at the time of the incident, she was doing Uber Eats, DoorDash, that type of stuff. She also was working at FedEx, and she's also worked at Wendy's. She lost the FedEx job due to this case. So that is in part one of the reasons we will be asking for first offender treatment, is that so that we can, hopefully if the court grants it, this will not impede her ability to go back in for employment. She's also involved in her church, 2819 Church, and as you have seen from the letters I shared with the state and the court, she does have family and friends that support her and really believe in her. Your Honor, just to get some of our views of the incident on the record, I don't believe, from speaking with Ms. Ballard and my review of the facts, I don't personally believe there was malicious intent in this situation. The night in question, she was driving her friend's vehicle, and there were 3 other friends in the car with her. And as you heard, they were doing Uber Eats, DoorDash, and she unfortunately was not parked in a parking spot and had her hazards on. And so when the 2 victims confronted one of her friends, there was the exchange of words. And one of the friends did throw the cup with the drink or whatever. And so then it kind of popped off from there. My understanding of the facts is that the Miss Fields actually stood in front of the car, kind of laid on the hood, or was like, no, you're not going anywhere. You know, we need to get a cop involved. And at that point, that's when Miss Ballard unfortunately tried to maneuver away. It's my understanding she didn't actually run over Miss Fields, but she, kind of started driving. And so then Miss Fields was knocked to the wayside. From my view of the CCTV footage, and from reviewing the body cam interviews with Mr. Patrick, he runs to get the cop. Well, then she's already leaving the scene. And so my view of CCTV footage is that he actually sort of jumps on the vehicle, not that she accelerated towards him, but I understand everyone has their perspective. And so that's what we saw in the CCTV footage. So that would just be something the jury would have to decide at trial. But in any event, he was injured, and we understand that he's had to go through a lot. So she is accepting responsibilities. She just did not mean for any of this to happen. Obviously, everyone involved could have made better decisions that day, Judge. We have no issue with a no contact, obviously, no issue with the stay away, of course, no issue with the defensive driving course. And of course, we would be requesting a restitution hearing. I'm asking for first offender treatment as well, which I've already mentioned. I'm asking for a sentence of 7 years probation. We don't have any objection to weekends in jail. I've already went over that with her. And so really, Judge, that's our request to the court.
Okay. Ms. Ballard, do you have any kids?
No.
Do you stay on your own, or do you stay with friends or family?
Yeah, like friends, family, back and forth.
You're moving around.
Yeah.
Okay. Is there anything you want to add? You don't have to say anything at all, but you have a right to be heard, just like Mr. Hoffman had a right to be heard. If there's anything you want to say.
Okay.
You want me to say it? Okay. Judge, we talked about it in the hall and prepping for this case. She completely denies laughing at anyone or pointing fingers. I don't know the other 3 passengers. I can't speak for them. Our investigator worked very diligently to try to get in touch with them. And of course, they are not answering our calls. So I can't speak if any of those people were laughing, but she is adamant she was not laughing. She was not being disrespectful. She really was scared after the exchange of the person in her car with the 2 victims. She just kind of freaked out. And so she wanted to make sure the court understood that.
Okay. Ms. Ballard, the other 3 people, first of all, was it your car or someone else's car?
Someone else's car.
Okay, but you were driving.
Yeah.
The other 3 people in the car, did you know them?
Yeah. Well, yeah. It was one of my homegirl, and then her boyfriend and his friend.
Okay, so you knew one person real well.
Yeah.
And then you probably knew her boyfriend.
Mm.
And then this other guy was kind of a stretch as to whether you knew him.
Yes.
Who was seated in the front seat next to you?
The guy I really didn't know so well.
Okay, the one who was most stranger to you.
Yeah.
And then your girlfriend, person you knew well, was in the back seat with her boyfriend.
Yes.
Okay. And why were you all doing DoorDash together?
Because we just needed some extra money. So she had the car. I knew how to drive.
Got it. Okay, so it was a collective effort. Someone could contribute wheels, someone could contribute driving skills.
They got out and got the food. Everybody.
It's a real team effort. Okay, all right. Well, Ms. Ballard, I find that there is a factual basis for your plea. I understand that it's a nolo plea, but that doesn't mean that there isn't sentence that accompanies it. And it certainly sounds like if this went to trial, a jury could find you guilty of assaulting both Ms. Fields and Mr. Hoffman. I'm not ignoring what Ms. Wood said. You'd have a defense. You might even choose to testify to talk about how you were scared and it wasn't intentional or who knows what. But it doesn't change the outcome of the pretty serious injuries. I think you're fortunate that you're not dealing with a vehicular homicide case instead. When a head hits the pavement, all sorts of things can happen, as you could see from that picture. I also find that your plea is knowing and voluntary. Voluntary means you are entering this plea because you've decided that's the way you want to move forward. And knowing means you've understood the things we talked about. Do you agree with that?
Yes.
Okay, I'm going to accept your plea. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith, for you?
Yes, Judge.
And Ms. Ballard, is it okay if someone in my office signs this as a first offender nolo plea for you?
Yes.
All right. We will defer restitution to another day. If the state marshals the information and wants to move forward, then we can certainly have a hearing as to that. Ms. Ballard, first offender is an opportunity that is available to you because you have no prior felony convictions. It means that whatever sentence I give you is a sentence and it's very real and you have to do all the things as part of it, but you're not a convicted felon. And if you successfully get through your sentence, then you can have this part sealed off. Should you go back to school or apply to other jobs, that's helpful. You ran into that issue with FedEx. You'll continue to run into that issue until this gets sealed up and you can have things sealed as a first offender. Assuming you successfully complete your sentence, it can stay sealed. The risk is that if while you are under sentence, and whatever sentence I give you, what the state asks for, your lawyer asks for, or something in between, it's going to be long. It's not just a few months. If during the course of that sentence you get in trouble again, not only do you have your new situation, but you'd come back here and the state would likely ask me to take away your first offender and resentence you. And you've got some pretty serious exposure here. The maximum you could get in this case is 40 years, 20 plus 20. I don't think that's what would happen if I took away your first offender status. But if what happens 6 months from now or a year from now is you hit someone with your car, I'm certainly going to take away your first offender status and there'll be a bunch more time. So if you're pretty sure that something like this wouldn't happen again, then first offender makes sense. But if you're working through some challenges that led to this and whatever was going on in Cobb last year, then first offender might not be a great idea. Do you feel like you understand the risks and the benefits of first offender?
I understand.
Do you want to be sentenced as a first offender?
Yes.
Okay, I'll do that. Ms. Ballard, I am going to sentence you on count 1 to 6 years to serve 1 year with the balance probated, and the same on count 2. So you are going to have a custodial sentence. I'm open to letting you turn yourself in, not today, but soon if you need a few days to get your affairs in order. But if you are ready to go into custody, then that can happen today. I'm going to let you talk with Ms. Wood about that. Let me finish the sentences. It will be a special condition of your probation, and you'll have 5 years of probation, that you get your GED. You may do that while you're in custody, in which case you don't need to worry about it when you get out. You can have no contact with Mr. Hoffman or Ms. Fields. You'll need to stay away from that strip mall on 10th Street. I'm not going to require a defensive driving course. Just you are driving again, you need to, of course, make different decisions while you're driving, to include not drive if someone is on your hood, but to keep the car stationary. So that's where we are. Do you need to talk with Ms. Wood for a minute about turn in?
What am I turning myself in for?
That's the sentence. So we need to talk.
Sure. You guys should talk. Do you have any questions about the sentence, Ms. Wood?
No, Judge.
Ms. Smith? Okay. All right. But so we're clear, we're not in a final plea setting.
Well, we preserved our rights, but.
Oh, you did?
Yeah, we did, because we were waiting on the medical, I think I'll be back.
Okay,
I'll be back though.
okay.
Thank you, Judge.
All right, Ms. Ballard, we're going to get back on the record in your case. You and Ms. Wood had an opportunity to discuss. I sentenced you differently from what Ms. Wood advocated for. I understand why she was pushing for a probation-only sentence. The state, of course, was advocating for 5 years in custody because of the seriousness of what happened and the nature of the injuries and their perspective that it was malicious on your part. I wasn't there, and I'm not going to attribute any particular intent on your part other than that it was clearly reckless, and recklessness can lead to criminal liability. And it was real serious. It wasn't just one person, but two people who were injured. So it may have been some fear on your part, but it also, you were operating a dangerous weapon in the form of that car. And so I came up with something that was in between. I think that's reasonable, but it's also serious. Ms. Wood, does Ms. Ballard want to go forward with the plea, or does she want to withdraw her plea and go forward with trial?
She wants to go forward with the plea, Judge, and we would be requesting a turn-in date.
Okay. Ms. Ballard, I am open to the idea of you coming in here a little bit later. I don't mean today, but another day. How much time was Ms. Ballard thinking?
I'll ask, Judge. I was going to see if the court would give her a couple of weeks, maybe have her come in on June 1st, which is a jury selection date for us.
You won't be here then.
I won't be here.
Okay, but you'll have a colleague here?
Yes.
Okay. Ms. Ballard, let me tell you how this is going to work. I will give you that reporting date. So you need to be here. You come to courtroom 8D. You've been here before, so you know how to get here. 8D, you need to be here at 9 o'clock. If you are not here by 9 o'clock and no one is reaching out to say she's on her way, flat tire, or the bus was late, then I'm going to go with the state's recommendation, and your sentence will be 10 years to serve 5 years. And you'll be a fugitive. You're not going to be hard to find, and your sentence will have grown by a factor of 5. So don't be late. If something comes up,
Can I do another date?
What's wrong with June 1?
That's too soon. Like, I have to get stuff in order.
It's not going to be sooner than June 1. I'm sorry. It's not going to be later than June 1. June 1 is stretching it way out. My inclination was going to be, how about Monday? As in, today is Thursday. I'll see you next Monday. That's what I would typically do. Ms. Wood has asked nicely. You have, for the most part, stayed out of trouble. I don't think you're going to do anything to Ms. Fields or Ms. Hoffman, Mr. Hoffman. I think they'll be safe during the time you are putting your affairs together. But June 1 is as far out as I'm willing to go. If you want to pick a day in May that you'd like to be here, that's fine with me. But June 1 is as late as it's going to be. Okay?
Mm-hmm.
So 9 o'clock, June 1. Do not be late because you'll get the sentence that the state asked for. Understand?
Right.
Okay.
Thank you, Judge.
You're welcome.
Judge, can I
Mr. Lee? Yeah. Can you get Mr. Lee?
This one.